My name is David Simpson and I'm a barrister here in 3 Verulam buildings in London. In this video, I'm going to talk about the types of dispute that can arise from mortgage-backed securities. MBS are the financial plumbing that sit behind the modern mortgage market. They allow banks engaging in residential and commercial mortgage lending to transfer risk to other investors through the capital markets. Mortgage-backed securities have been around since the 1970s, but they gained a certain notoriety during the credit crunch because they were seen as creating moral hazard in the mortgage markets by transferring too much risk away from the banks originating mortgage loans. This meant that they were seen as encouraging reckless lending habits. However, they remain a key component of the modern financial system, and the total value of all outstanding MBS currently stands at over $12 trillion. More specifically, MBS are tradable financial instruments, which are often listed on markets such as Euronext in Dublin. They allow a bank to securitise the revenue streams coming from a portfolio of residential or commercial mortgages. Residential mortgage-backed securities, or RMBS, are backed by large diversified pools of home loans. Commercial mortgage-backed securities, or CMBS, tend to be backed by loans secured on diversified multiple-use commercial property, such as, for example, shopping centres. The securitisation process effectively turns the interest payments due under the mortgages into coupon payable on securities. The effect is to transfer some or all of the risk associated with the mortgages away from the financial institution and onto the investors holding the securities. The securities are tranched into different classes with different interest payments and different levels of risk. So the structure that I'm going to be looking at in this video is this, or at least this is a diagram in which I have attempted to show how a structure like this works in practice. This is a particular type of mortgage-backed security that has been considered in quite a few cases in the English courts. It is a mixed CMBS-RMBS structure, and if it looks a little complicated, that's because it is. However, I'll take it step by step to show how it is put together in the first place, how it functions in practice, and how it responds to certain events during the life of the mortgages backing it, such as defaults on the mortgages or mortgages being prepaid before their maturity. So at the top, you can see that the bank or originator enters into, or simply acquires, a portfolio of mortgages with third-party borrowers. These are referred to as the reference obligations. Some of them are commercial mortgages, some are residential. The borrowers pay monthly interest on their mortgages to the originator, and at the end of their term they pay back the capital. And if they default, then the originator has all the normal powers to enforce their security. However, the originator wants to protect itself from the risk of default. In order to do that, it incorporates an SPV known as the issuer and enters into a credit default swap, or CDS, with it. The terms of the CDS are set out in an agreement between the originator and the issuer, and the exact degree to which the CDS provides protection to the originator will depend upon those terms. However, typically, the notional value of the CDS reflects the total value of lending to the reference obligations. The CDS operates like an insurance policy. The originator pays a quarterly premium to the SPV for that protection. The premium typically equates to some or all of the interest paid by borrowers under the reference obligations. However, it is important to remember that the CDS is separate from the reference obligations, and it is not as simple as money passing through the hands of the originator down to the issuer. Of course, the CDS obliges the issuer to indemnify the originator for losses suffered through defaults on the reference obligations. But the issuer is just an orphan SPV. Its shares are typically held by a charitable trust for tax purposes. It has no assets of its own and cannot draw upon assets held by others. So how can it provide the protection that the originator seeks under the CDS? The answer is that the issuer issues notes to investors in order to generate a pool of funds which are then held on trust to be drawn upon as and when needed to meet commitments under the CDS. If there are no defaults, then the funds go back to the investors on maturity. If defaults do occur, then some or all of the funds go up to the originator, and the investors may find their particular class of notes wiped out. The structuring of this arrangement goes like this. The issuer enters into a trust deed with a trustee. Under the trust deed, the notes are constituted. The terms of the notes are set out in the trust deed, and the trust deed contains a covenant from the issuer to the trustee to pay all amounts due under the notes. The trustee holds the benefit of that covenant on trust for itself and for the note holders. The manager and arranger take those notes to the market with the aid of a prospectus or offering circular prepared by the arranger. In this way, they bring in funds from investors. The manager transfers funds equating to the notional value of all of the notes to the issuer, which the issuer then deposits in a cash deposit account. Those funds may in turn be invested in securities maintained in a securities custody account. Whether in the form of cash or securities, this fund represents the principal of the notes and the notional under the CDS. It sits waiting to see whether it will be needed in order for the issuer to make payments to the bank under the CDS. At the same time, the issuer appoints a range of service providers to fulfill various functions under the note structure. The payment agent and agent bank deal with the mechanics of payments under the notes. The account bank agrees to maintain certain bank accounts for the issuer. The calculation agent performs calculations of each side's liabilities and entitlements under the CDS. The cash manager provides, cash management services in relation to the issuer's accounts. The master and special services are responsible for the servicing, collection and enforcement of each reference obligation and its related security. This means that they monitor the reference obligations and take action in the event of a default. The corporate services provider provides administration and secretarial services to the issuer. And finally, the issuer enters into a liquidity facility agreement with the liquidity facility provider, pursuant to which the issuer is entitled to draw upon a committed liquidity facility to ease cash flow in certain situations. Each of the professional service providers is termed an issuer secured creditor. Each of them is a party, along with the issuer, to the issuer deed of charge. This is a crucial document which performs two key functions. First, the issuer grants to the trustee extensive charges over all its contractual rights in the transaction documents for the notes, along with any money and securities held in its accounts. The trustee holds such security on trust for the benefit of itself and the other issuer secured creditors. Second, the issuer secured creditors agree to subordinate any rights, claims or remedies that they have under the respective agreements to a payment priority waterfall set out in the issuer deed of charge. I will come in a moment to how those waterfalls work, but the important point is that this subordination gives the issuer secured creditors skin in the game. They are providing services and accepting some risk that they will not be remunerated for them under the note structure. When it comes to understanding the economics of the structure that I've set out, I think it's useful to know that many of the roles are actually performed by the same person wearing different hats, and in many cases that person is the bank originator itself. The bank or an affiliate of the bank is likely to maintain the cash deposit account and to act as the master servicer, the special servicer and the calculation agent. It is likely to be the manager whose injection of funds makes the structure liquid in the first place. It's also likely to be the holder of the Class X notes, whose role I will come to shortly. So, whilst this may look like a cast of thousands, it is in reality a cast of maybe 4 or 5. It's also important to understand something about the kind of democratic arrangements that exist for the governance of this structure. The trustee represents the interests of the note holders within the note structure. Only the trustee has power to enforce the obligations of the issuer, However, it is entitled to refuse to take action without a direction from a supermajority of the most senior class of notes outstanding, plus full indemnification against the costs of doing so. Only if it fails to take action can note holders take matters into their own hands. So, in the event of a dispute, the primary concern of note holders is normally to ensure that the trustee takes action on their behalf. Only if the trustee refuses are the note holders likely to seek to take action themselves, and even then, as you would expect, a little grudgingly. Of course, there are also likely to be many different note holders in any particular class of notes, so there are also issues about managing claims brought by multiple claimants should the dispute proceed to court. Clearly, this is a structure that involves a very large number of interlocking contractual arrangements, and unsurprisingly, most of the disputes that arise are essentially disputes as to contractual construction. The courts will obviously have regard to the documentary, factual and commercial context to each contract, that is, Arnold and Britton, and it will read the suite of documents together and try to avoid over-literal interpretation, that's Sigma Finance. So a good example of this is Gemini and Danske, in which Mr. Justice Cook was aided in determining whether certain sums were due under the cash management agreement by reading it in the context of the deed of charge and the liquidity facility agreement, with the aid of evidence as to the commercial purpose of the liquidity facility. However, there are limits to how far this can be pushed. In US Bank and Titan, Mr. Justice Snowden was unwilling to construe the servicing agreement in the light of apparently contradictory statements in the prospectus, because the prospectus was not a contractual document and, in any case, contained a disclaimer which made clear that everything it said was qualified by the transaction documents themselves. He was also unimpressed by attempts to refer him to documents from other CMBS transactions as a guide to the actual CMBS transaction in front of him. Finally, the limits of commercial common sense were explored by Mr. Justice Arnold in Deutsche Trustee and Cheney Capital. In that case, the servicing agreement provided that the special servicer could only be replaced if 3 named rating agencies gave an acceptable rating to the proposed successor. One of those agencies had since adopted a policy of not providing such ratings, so in a sense this was a question of how far the construction of the documents could be pushed in a situation where something had gone wrong. Mr. Justice Arnold accepted the position of Cheney Capital that it did not appear sensible to require a rating from a rating agency which refused to give one. However, as he put it, the problem with Cheney's interpretation is that this is not what the words actually say. So in the event the inability to comply with the requirements of the servicing agreement meant that the special servicer could not be replaced. So to return to the structure, the note holders are obviously interested in 2 things: receiving income in the form of interest payable on their class of note, and recovering the principal invested upon maturity. At its simplest, the return of principal goes like this. The reference obligations mature in the sense that the borrowers repay the sums borrowed. The CDS expires. It may be that the CDS expires before the reference obligations mature because one does not depend on the other, but the terms of the CDS are likely to reflect the terms of the mortgages. With the expiry of the CDS, the cash deposit is no longer required and is released. It is then used to redeem the notes through the pre-acceleration principal priority of payments waterfall. This simply means starting with the most senior and working through to the most junior. And there, you can see that the notes have been fully redeemed, and the note holders have recovered their principal on top of whatever payments of revenue they have received prior to maturity. However, life is never that simple, and the most interesting scenarios under this structure arise when things go wrong. Most obviously, this takes the form of a reference obligation defaulting and becoming insolvent. This is referred to as a bankruptcy credit event, which is what we can see here. If a bankruptcy credit event happens, then the originator serves on the issuer, the cash manager, and the trustee a credit event notice. The calculation agent then calculates a liquidation loss amount. This is essentially the swap notional amount associated with a particular reference obligation minus the net recovery amount, so whatever is recovered in the insolvency. It should be noted that this calculation can take some time to reach because it depends upon the progress of the insolvency. So the note holders may know that they are about to take a hit without knowing how big that hit will be. Once the figure is established, the issuer uses the funds in the cash deposit account to pay a cash settlement amount to the originator. At the same time, the most junior notes are written off in an amount equivalent to the cash settlement amount. So you can see here that the Class E notes have been written off. They were the most high risk and paid the highest rate of interest, but carried the greatest risk to capital. That risk has now eventuated and capital has been lost. Another key scenario affecting note holders is the early repayment of a reference obligation by a borrower, which is what you can see here. Whatever reason there is for this prepayment, it results in a corresponding reduction in the swap notional amount. This means that funds are released from the cash deposit account, and instead of going up to the originator, they go down through the pre-acceleration principal priority of payments waterfall to redeem the notes, starting with the most senior. So you can see here that the Class A notes have now been fully redeemed. So far we have only looked at the repayment of principal on the notes and at payments under the CDS. However, there is obviously coupon to pay on the notes, plus a whole list of issuer secured creditors to pay. These payments of revenue are made out of two sources of funds. First, premium payments under the CDS. Second, profits generated from securities held in the securities custody account, along with interest on the cash held in the cash deposit account. Payments are made periodically on the note interest payment date, which is likely to be quarterly, reflecting payments being made to the originator under the CDS. The revenue payment filters down through the pre-acceleration revenue priority of payments waterfall, which is very complicated, but it looks a bit like this. First, the trustee is paid. Then, each of the issuer secured creditors is paid in their respective order of priority. If funds are still available, interest is then paid on the notes. There is then a further sweep to make subordinate payments to the account bank and the liquidity facility provider, before finally, if any revenue remains, that is paid to the Class X note holders. Importantly, the issuer secured obligations take priority over the payment of interest to the note holders. The notes are paid in order, so it is possible that income will be insufficient to pay interest all the way down to the Class E notes. On the other hand, if there is surplus income following the payment of interest on all the notes and payment of the further subordinate debts to the issuer secured creditors, that surplus is likely to go to the Class X notes. The other controversial issue as regards the payment of revenue has been as to the entitlement of Class X note holders to retain surplus interest where that surplus interest has been generated by reference entities breaching lending covenants and being subject to the obligation to pay higher levels of default interest. This has been described as objectionable because the holder of the Class X notes is very likely to be the originator bank, and therefore the person who selected the reference entities in the first place. It might thus be seen to be rewarded for the fact that the reference obligations are in default. In Credit Suisse Asset Management and Titan Europe, the Court of Appeal decided by a majority that the Class X notes were not entitled to retain surplus income in these circumstances, and that, in fact, any surplus income generated by default interest should remain with the issuer. Because the issuer is an orphan SPV whose shares are held by a charitable trust, that effectively meant that the money should go to charity. Lady Justice Arden thought that it was difficult to think of a commercial transaction intended to reward a person for the default of a third party. Lord Justice Underhill thought that the payment of default interest to charity was not illogical, even if it was not part of the commercial purpose of the parties, whilst Lord Justice Briggs, in a strong dissenting judgment, took the view that the coupon payable on the Class X notes was simply what had been bargained for and marketed to the other note holders, such that there was nothing objectionable about the structure. I think this is an interesting example of how far commercial common sense will get you in the construction of these kinds of financing documents. That brings me to the question of acceleration. The acceleration of the notes has serious and dramatic effects upon the rights and interests of all parties. Most particularly, it entitles the issuer secured creditors to assert claims against the principal rather than just the revenue under the note structure. Acceleration can only arise if a note event of default occurs. Typically, these are the failure of the issuer to pay interest or principal when funds are available, breach by the issuer of an obligation under the trust deed, the issuer being unable to pay its debts, although importantly this does not mean a situation where funds are simply unavailable to redeem all of the notes, and finally certain defaults under, for example, the CDS and the account agreement. In practice, acceleration is only likely to arise in a stressed situation, which is what you can see in this diagram. So you can see that the 4 reference obligations in red have now suffered bankruptcy credit events. 2 others have prepaid, and only the 2 in blue are still operating. The cash deposit account is seriously depleted through payments made under the CDS when the reference obligations defaulted. As a result, the Class D and Class E notes have been written down. As a result of the prepayments, the Class A notes have been redeemed, so the Class A note holders got away with their money. This leaves the Class B and Class C note holders. If a note event of default occurs, then the trustee is entitled to serve an acceleration notice. This results in the early termination of the CDS and the payment of any settlement sum arising out of that termination. Then, most importantly, the remaining principal in the cash deposit account and revenue from the various different sources are now merged into a new post-acceleration and priority of payments waterfall. In this waterfall, the issuer secured creditors still have priority over the note holders, but are now entitled to be paid out of principal. In theory, any surplus left at the bottom of the waterfall goes to either the Class X note holders or the issuer. However, in the kind of stressed situation in which an acceleration is likely to arise, it is probably unlikely that there will be sufficient funds to redeem all of the remaining classes of notes. So here, the waterfall is sufficient to redeem the Class B notes, but not Class C. This is why the potential for acceleration is highly likely to create conflict between different classes of notes. The Class B note holders might like to take their chances on acceleration, thinking that there is enough money left in the structure to pay them out. The Class C note holders will want the opposite and will want to keep the structure operational for as long as possible in the hope that they will be redeemed. Only the trustee has power to enforce the obligations of the issuer. However, as I said before, it is entitled to refuse to take action without a direction from a supermajority of the most senior class of notes outstanding, plus full indemnification against the cost of doing so. Only if that direction is given and then ignored can the note holders themselves take direct action to enforce the notes. In this structure, Class B are the most senior class outstanding and have the power of life and death over the Class C notes. But they also need to think whether they wish to force the trustee to act and to indemnify it fully for the cost of doing so. Meanwhile, the Class C note holders may well be looking to whether they can try to prevent acceleration of the notes, perhaps through an injunction or declaratory relief on the basis that an event of default has not in fact occurred. I think it's worth bearing in mind that sometimes hedge funds will buy into perilously exposed note classes, like the Class C notes here, precisely because their exposed position means that their market values may be very low compared with the notional value that might be achieved if acceleration can be avoided and full or partial recovery achieved. So there is money to be made in adversity and plenty of scope for interesting disputes between the different classes of note holders. And that brings me to the end of this video. I hope you found it interesting. If you would like to discuss any of the issues that I've talked about today, you can email me on dsimpson@3vb.com.